Okay, so welcome everyone to our virtual family council meeting. I'm sorry for the delay. We're going to start with our confidentiality reminder.
And for our confidentiality reminder, please refrain from using the name of your loved one. Do not name specific facilities. Please use a nursing home or the personal care home to present to the group. If you need specific assistance, please use the chat feature to state which county you are in, and we will get you connected to the correct ombudsman. And finally, these calls have public access and are designed for family members and friends of residents in long-term care facilities.
So next we will get our virtual meeting tips from Jay. And then we will be moving on to estate and long-term care planning, as well as teaching nursing home models. And Jay, take it away.
So for the tips, everyone. First of all, if you have not muted, please do so. You've all been placed in mute upon entry. We'll open the lines in a bit so that you're able to share. If you'd like to speak or have a question, please use the raise hand feature. Once you raise your hand, we'll know to acknowledge you and unmute your line. If you hover your mouse near the bottom of your screen, you'll see the participants tab. That can be expanded if you'd like to see who's on the call. The chat feature is at the bottom of your screen as well. Once you maximize it, you will be able to chat with presenters or others during the meeting. Closed captioning is available during the call. If you would like to enable that, please click on the CC icon at the bottom of your screen. If you need to step away, you can stop sharing your camera by clicking on the camera icon at the bottom of the screen. You can click on it again to start sharing your camera again. And finally, here's my part. Concerns or complaints can be directed to the State Ombudsman's Office. You can reach me at 717-783-8975 or by email at LTC-ombudsman@pa.gov. Eliza, back to you.
Thank you, Jay. Now we'd like to introduce Lauren, who's going to do our presentation for the day.
Hi, thank you so much for having me today. Are you going to control the PowerPoint, Eliza?
I can. I absolutely can. Just I'm watching it, so just let me know when you want me to advance slides if I don't know by myself.
Okay, that's fine. You can go to the next one if you'd like. Okay, everybody. So as you saw from the title of the presentation for today, we're going to be talking about estate and long-term care planning and some basics surrounding that. I am an elder law attorney, so this is a pretty significant part of my practice every day, is helping people navigate the maze which goes along with not just basic estate planning, things like wills and powers of attorney, but also combining that with some what we consider a lot of times some more advanced planning that we all often have to at least consider. And that's the what if something happens and we need to go to a nursing home or we have a long-term care need. And those are things that in your line of work, I'm sure that you see and you encounter those people just as I do all the time. So I'm going to be also talking as well about the estate process a little bit today, because that's an important thing that people are always asking a lot of questions about. And hopefully this will be beneficial to you, not just from a professional standpoint, but also on a personal level as well. And some of the definitions that I'm going to go over here so that we are all clear on some terminology. When I use the word estate today, there's really two areas when we use the term estate. And I find that this can get a little bit confusing for people sometimes. So typically when we think of the term estate, we're going to be thinking about what happens when a person dies, their assets at the time of their death. But there's also another time when we use the term estate, and that is in the context of a guardianship, when we have an incapacitated person who has been deemed incapacitated by a court, and they have a guardian appointed to assist with their finances and their real and personal property. And we call that guardian the guardian of that person's estate. So that term can be used interchangeably, both after someone's death and then also in the context of a guardianship while they are still living. The term probate is another very commonly used word that I find there's a lot of misconceptions that surround. Probate basically means assets that are going to be in your name only at the time of your death. So those would be real estate, life insurance policies, bank accounts, retirement accounts, any asset that does not have a joint owner and does not have a beneficiary designated. And those probate assets are always going to pass to your heirs, either according to your will, if you have one, or according to the state intestate laws, if you don't have a will. And contrasting that, then non-probate is always going to mean assets that you have a beneficiary designated for, or that are joint or owned jointly with someone else, or that might even be owned in a trust. And so we handle probate assets and non-probate assets a bit differently. You can go to the next slide, please. So I always like to start with powers of attorney because I get a lot of questions about them, a lot of hesitancy about them. But I personally think that these are one of the most important documents that anyone can have, regardless of your age and regardless of your health. So your power of attorney is going to appoint an agent or agents to act on your behalf or make decisions for you regarding your real and personal property. And then, of course, there are also medical or healthcare powers of attorney, which will appoint agents to act on your behalf with regard to your medical decisions, or also more personal decisions, such as, getting you admitted into a nursing home, for example. Now, from a financial perspective, most powers of attorneys are going to authorize withdrawals from bank accounts. They're going to authorize signing checks to make sure that bills are getting paid, opening accounts or closing accounts, removing names from accounts, getting information on things like life insurance policies or retirement. And in some cases, even beneficiary designation changes. And, again, in your line of work, I'm sure that you unfortunately see a lot of people, maybe not a lot, but I'm sure you've seen people that are misappropriating assets using a power of attorney. And that certainly does happen, unfortunately. But the one thing that I always tell people, and when I do this presentation for banks, I often say the same thing because they see that often as well. If somebody makes an unusual request, or it seems like they're doing something that might not make a whole lot of sense with the person's finances under a power of attorney, I always ask that we consider and question the agent as to whether or not they are doing that under the advice of counsel. Because I know in the long-term care planning world, when I'm trying to get people qualified for Medicaid benefits, depending on what the power of attorney allows, I have asked people to do some pretty wacky things. Again, assuming that the POA does allow for it. But I've been questioned then by a bank, as in they call me and they're like, well, wait a second, this doesn't sound like this is something that this person should be doing. And then I usually will say, no, it's fine. This is pursuant to my advice. So that's the one thing that I always like to tell people, is just to see if they have a qualified elder law or estate planning attorney involved if you happen to notice anything that might seem a little out of sorts that the power of attorney might be doing from a financial perspective. Next slide, please. So with powers of attorney, there are a few different ways that they can be set up. You can have multiple agents acting on someone's behalf. If you see the word or, that's typically going to mean that those agents can act jointly or they can act independently. If you see the word and, it usually means that both agents are going to have to be joined at the hip and acting together, unanimous decisions at all times. This can especially be troublesome whenever you have not just 2 agents, but if you have sometimes 3 agents, and I've even seen POAs that have 4 agents. And that can be a recipe for disaster for the obvious reasons if you have everyone that has to act all together, all at the same time. So the POAs that I most often write are going to give that the agents that independent authority. I always tell people, you know, if you're appointing somebody that you don't really trust, that you feel like you need to have that system of checks and balances, then you're probably not appointing the right person. And we might need to reevaluate who's going to act as our agents. Most powers of attorney are going to be immediately effective when the principal signs it. That means that the agent can act under 2 circumstances, either at the principal's direction or when the person becomes incapacitated. Some powers of attorney are only effective when the principal is incapacitated, and they're normally we'd have a doctor's certification attached to the document in that situation. I don't often do those types of powers of attorney. We call those springing, and it's primarily because they're really quite unworkable in a lot of situations. If you have an emergency situation, it can be kind of difficult sometimes to get that written certification from the doctor in a timely manner, at least. And also it really, you know, it kind of backs the family into a corner where, you know, I use the example of it's snowing outside and mom and dad don't want to go out to the bank. Well, the agent can't use the power of attorney for even something as simple as banking at their parents' direction, because the power of attorney only allows for it to be used if mom and dad are actually incapacitated. Another very important point is that powers of attorney are not valid after somebody passes away. So upon death, the power of attorney basically becomes a moot point. Next slide, please. Do I need a will? That's another question that I get from people all the time. And my answer is not everyone needs a will, and that's usually a surprising comment. But it's very important to review your assets with your attorney to determine whether a will is actually necessary. Because remember, your will distributes only your probate assets. If you have no probate assets, then you might not need a will. And it really depends on your family situation and other facts. But it's just important to get that scenario reviewed so that you at least know what's going to be the best recommendation for you. But it's not always necessary to have a will. Your will can distribute your probate assets and also name a guardian for minor children. It can establish a trust for minor children, for disabled or special needs loved ones, or other people that you might have concerns about. For example, if you have a loved one in the family that might have some issues with financial responsibility or substance abuse, and you want to include them in your estate planning, but you don't necessarily want them to inherit money outright that might get spent inappropriately or be used on something like alcohol or drug use, we can establish trusts that are actually written into a will that are designed to protect that money on that heir's behalf. And then, of course, your will is also going to appoint an executor who's going to administer your probate estate on your behalf. Next slide, please. Revocable trusts. So this is, aside from do I need a will, this is probably the next most common question. Everybody assumes that they need a trust, and the reality is a lot of people don't. Trusts do not offer, certain types of trusts, let me clarify that, don't offer quite the protection that people often think that they do. And I also find that there's a lot of misconceptions on what they actually are. And a revocable trust is the most common type that you might see. It's also called a living trust. And defining what a trust is, let's start there. A trust is basically a relationship in which one party, which we call the settlor or the trustor, is going to give another party or trustee the right to hold title to property or assets for the benefit of a third party, which is the beneficiary or multiple beneficiaries. And with a revocable living trust, normally the settlor and the trustee and the beneficiary are all going to be one person or persons, at least initially. And then once that person dies, then the successor trustee is going to step into place. And then the next layer of beneficiaries are going to benefit from the trust. Now, what does a revocable trust do? It is going to be a non-probate asset. Any assets that when you die are in your trust, that's all non-probate. So it is going to reduce estate administration costs, such as probate fees and legal fees. The legal fees on an estate are significantly lower than on a trust. It's also going to provide some continuity in terms of asset management. For example, one of the big concerns when somebody dies is, how am I going to access the money to pay their bills? Well, if there is a bank account that is actually in the trust, there's no break in the chain, so to speak, as to who can access that bank account, because the successor trustee is able to step right in pursuant to the trust documents and have immediate access to that account in order to pay bills or do whatever is necessary. Now, a revocable trust, because the settlor is also going to be the trustee and the beneficiary, there's going to be a lot of control that is going to be able to be exercised by the settlor. And so there's not going to be any protection when it comes to taxes, creditors, or nursing home. A lot of people think that these trusts, if they go into a nursing home, that anything in the trust is going to be protected, and that is absolutely not true. A revocable trust, I always tell clients, it's kind of like my hand. I can still control it, even though it's all the way out here, but it's still connected to me. So there's not much of a benefit from that perspective. And there's also going to be inheritance taxes on the full value of the trust assets as well. Next slide, please, Eliza. So as I just said, you're not really going to get that asset protection when it comes to long-term care or other creditors. There's not going to be a reduction in inheritance taxes, and there's not going to be a reduction in income taxes. So what are the benefits to a revocable trust, and when do we use them? You can go to the next slide. You're still able to retain control in the use of your assets when you set up a revocable trust. You can amend the trust at any time. You can revoke the trust at any time. So again, you get to still keep a lot of that access and control, which is important to a lot of people. You have that availability of the trust assets when you die, meaning that the successor trustee is able to step right in and do whatever is necessary to administer the trust. It does avoid the probate process and that continuity of the management of the assets after your death, but also during a time of disability as well, which is an important point. If you would become sick or injured as a result of an accident or incapacitated for any reason, your successor trustee would be authorized to act in that case, sort of like a power of attorney being your agent, except they'd be doing it with regard to any of the assets in your trust. And I most typically am going to use revocable trusts for people who are going to have interesting family situations, like maybe it's a blended family or a second marriage, and we have stepchildren, or maybe we've got, you want to provide for your spouse, but you also want to make sure that your children are going to inherit from you down the road as well, things like that. And also whenever we have multiple, sometimes just one, but a lot of times when we have more than one piece of real estate, especially if it's going to be in multiple states, then trusts are a really, really good tool to ensure that we're not going to have to open multiple probate estates whenever you pass away. Next slide, please. alternatives to revocable trusts. Now, this doesn't necessarily apply whenever we're talking about real estate, but when we're talking about people who don't have any real estate and just have monetary assets, I like to throw these two ideas out there because sometimes we can accomplish the same goals without the initial expense of a trust plan, because they are expensive to set up on the front side. And these are two ways that we can do that. Joint bank accounts, which are also going to avoid the probate process and will actually reduce inheritance taxes for the person that's going to inherit them when you're gone. But when you add somebody as a joint owner on your bank account, you're giving them complete access to your money and ownership of your money. And so that's something that you have to really, really strongly, think about that before you do it. And then there's also ways that you can make bank accounts, CDs, money market accounts. You can make all of those things pay on death, or also called in trust for. And these operate very similar to a trust in that the beneficiaries have no ownership or access to the bank accounts or to the money during your life, but it does avoid the probate process and it becomes essentially a beneficiary designation, very similar to a trust. That's something that I recommend to a lot of my clients because there's really no upfront cost to it, but it operates very much like a trust with regard to financial accounts. Next slide, please. Now, if we're talking about asset protection, my little house got bumped down somehow. But whenever we're talking about asset protection, especially in the context of nursing homes or long-term care, that's when we're going to be looking at an irrevocable asset protection trust. And this is a pretty strict form of planning. And I really only do it for people that are up to a certain asset level. But basically, the assets in this type of trust, whether it's going to be money or real estate, are going to be protected from creditors, including nursing homes. The terms are going to be very specific. You're not really going to have access to the principal of the trust. So, for example, if you put $100,000 into an irrevocable asset protection trust, it might be invested. A lot of times that money is going to be invested for you, and it's going to earn something per year. You can receive that income that is earned on your investment, but you can never access again that initial $100,000 investment. That's going to be preserved for the next layer of beneficiaries after you're gone. So an irrevocable asset protection trust is a really good way to ensure that preservation of inheritance in the event that you are going to be in a nursing home at some point. Now, this is going to be subject to the Medicaid 5-year look back, because by putting assets into that trust, you are relinquishing all ownership and control. It's essentially a gift. So that initial investment or any gifts that are made to that trust are going to be subject to the look back if you have to apply for Medicaid. Next slide. Okay, so this is going to talk about the estate and probate process a little bit. I'm not going to dwell too much on this, but I find that, again, there's a lot of questions about it. This just gives you a very general overview of what we do after someone dies and we have to open an estate for them. And the first step is always going to be to file the will, if there is one, and a death certificate with the county register of wills. It goes by the county of the person's residence at the time of their death. The personal representative, which is going to be called either an executor or an administrator, is going to be sworn in by the register, and they're going to get something called short certificates, which are sort of like the personal representative's badge of authority that says that they are the person who had the authority to act on behalf of the estate legally. There's a lot of statutory requirements when it comes to a probate estate. We have to advertise the opening of the estate to give creditors notice of that person's passing. We have to send notices to all of the beneficiaries and heirs of the estate. There's always going to be the process of liquidating assets such as bank accounts, investment accounts, real estate, selling personal property. All of that's going to get pulled into an estate account, which is where we are going to pay things like taxes, bills, administrative costs. There is an inheritance tax here in Pennsylvania, which ranges anywhere from 4.5% to 15%, depending on your relation to the person that you are inheriting from. In Pennsylvania right now, it's been a little bit quicker, but typically it's a 6-month wait. So when we file an inheritance tax return and pay those taxes, it takes about 6 months for the Department of Revenue to approve those that tax return. And so when people ask me, why are things taking so long with even a basic estate administration, it's because we're waiting on that approval, and it does take typically up to at least 6 months to get that. But once we know that we have got all of our inheritance taxes paid, then we can make payments to any creditors, again, whether that's administrative costs, medical bills, credit card bills, any of those things. And then the absolute last thing that we do is make our distributions to the beneficiaries and the heirs. And I often tell people that a full estate, especially if we have real estate to sell, at least here in Cambria County where I live, that's going to take about 12 to 18 months. Next slide, please. There are a few things that you can do that are alternatives to a formal estate. There's something called a small estate, which only comes into play if you have assets that are under $50,000 and no real estate. And then it's also important to know another streamlined procedure. Sometimes I have people, especially people who were in a nursing home and on Medicaid, and they're only allowed to have $8,000 or less in their bank account. A family member can go to a bank and present a copy of a funeral bill and a death certificate. And if the account is under $10,000, the bank will release that money directly to the family member. So that's just a little trick that sometimes people don't know about. Next slide, please. Can I get a time check? I'm just not sure exactly what time you would like me to stop.
You're good.
Am I good?
Yep, we can go all the way to 6. So you're
okay.
Plenty of time.
Just checking. All right, wonderful. Okay, so guardianship. Now, this is something that you've all, again, probably encountered having to work with guardians or folks that have been declared or maybe should be declared incapacitated by a court. And guardianship is most often used when we have someone that either does not have a power of attorney, does not have a valid power of attorney. We have issues where there's perhaps an existing power of attorney, but family members are quarreling and fighting and trying to invalidate something, or maybe doing something that's not in the person's best interest. There's a lot of instances where even when there is a perfectly good power of attorney in place, we still need to have that little bit of a higher level of authority through a guardianship. So through a guardianship, a person is going to be declared incapacitated by a court, the orphans court, which means that they have their ability to receive and communicate information is going to be significantly impaired, either totally or partially, that they are unable to manage their finances or meet the essential requirements for health and safety. And when a guardianship is determined or approved, the court order is going to direct who the guardian is, what they can do, and all of those things. Whether it's guardian of the person, which is going to mean meeting those requirements for the person's health and safety, making medical decisions, handling things like nursing home admissions, hospice admissions, whatever that might entail. And then we also have guardian of the estate, which, as I explained initially, estate in this context is going to mean finances and real estate. It does not mean that the person is deceased. Next slide. Now, guardianships are a really good segue into talking about some special needs planning, because most often most of the time, the guardianships that we see are not as a result of a contested situation with a power of attorney. A lot of times a guardianship is going to be done because I have an elderly person who does not have a power of attorney. And a lot of times they have advanced dementia where they are no longer cognitively able to sign a power of attorney. But then I also have a lot of situations where I have children who have, well, I shouldn't use the term children because it would be that they're over the age of 18, but they're adult children who have special needs or disabilities to the point where oftentimes they're either in a group home or their parents might be still providing a significant amount of care and decision making for them. But once somebody turns the legal age of majority, once they are a legal adult at age 18, their parents, no matter how much assistance is needed, they are no longer legally able to make decisions for that person or act on that person's behalf. And so that's whenever we often will get into a guardianship. And then during that same conversation that I'll have with parents in that situation, and it's usually parents, sometimes it's other family members, we're usually also going to talk about whether or not something like a special needs trust is needed. And a special needs trust is a specific type of trust that is designed to protect eligibility for need-based benefits such as SSI or Medicaid for disabled individuals. And there's three types of special needs trusts. I'm going to really talk about two of them today. That there's what we call a first-party special needs trust, which is funded with the disabled person's assets. And that's typically going to be used whenever we have a situation where there was poor estate planning done by the disabled person's relatives, such as their parents, and the disabled individual receives inheritance, whether it's life insurance or a house or money from the bank, they receive that outright. But because they are on need-based public benefits, they can only have, for SSI, it's only $2,000. So if they are to receive a lot of times any amount of inheritance, it's going to jeopardize their ability for those benefits, their eligibility for those benefits. So what we can do is we can take that inheritance, that money, those assets, and we can put it into a first-party special needs trust. And by doing that, it takes those assets off the table from eligibility for SSI or Medicaid. The money and the assets are still there for the disabled beneficiary's needs, but it no longer is considered an asset that's going to jeopardize their eligibility. Now, for first-party special needs trusts, because we are using the disabled beneficiary's own money, essentially, if I inherit something, even if I then turn around and put it into a trust, it's my money first. Because of that, there is going to be a Medicaid payback after death. So when the disabled beneficiary dies, before anyone else can touch that money, before even a funeral can be paid for, Medicaid has to be paid back first. So that's kind of the catch to a first-party special needs trust. We can use the money for the disabled person during their life, but once they die, Medicaid's going to want to get paid back. Another time that we often use those types of trusts is going to be whenever there's something unfortunate like an accident that might have caused the disability, and there was a judgment or a settlement that was obtained. And in order to ensure that that person who is now in most cases no longer able to have gainful employment is going to be eligible for benefits that they might need, we will often go ahead and take the money from that judgment or that settlement and put it into a special needs trust for that person. Now, there's also third-party special needs trusts, which first party is typically going to be used, again, when we don't have the proactive planning in place, either because we, out of ignorance or out of the fact that it's something like an accident that's unforeseen. But with third-party special needs trusts, those are going to be typically set up by someone who wants to leave an inheritance for their disabled or special needs loved one, but they know that that person is not able to receive that inheritance outright because of their benefits. So a third-party special needs trust is going to be set up by someone else as part of their own estate plan. For example, if I have a disabled child who I want to leave as a beneficiary of my estate, instead of leaving my child as the direct beneficiary, my son's name is Luke, for example. Instead of naming Luke in my will, I'm going to name the Luke Presser Special Needs Trust instead as the beneficiary. And so that inheritance is never going to touch Luke's fingers. He's never going to lose eligibility for his benefits. It's going to automatically just go into this trust for his benefit. And because that money is never his, there's also not going to be any Medicaid payback. So I'm able to name additional beneficiaries in that third-party special needs trust so that whenever my disabled son or daughter passes away, then those contingent beneficiaries are going to be able to benefit from the remainder of the trust rather than it going back to pay back Medicaid. So the third-party special needs trusts are a really, really great proactive estate planning tool that I highly recommend you consider if you have a special needs or a disabled loved one that you'd like to include in your estate plan. Next slide, please. That's it. Look at that. I thought I had some more in there. Do we have any questions?
I believe Corey is on the chat this evening.
And I have no one on hands.
It does look like we have one hand.
Oh, there it is. Elena Sellers. I'm sorry, Elena.
Hi. This is a question I've had for years. I can't seem to get a clear answer, but I am my mom's financial and healthcare power of attorney. She's in a nursing home, and her Social Security is being directly deposited into her account at the nursing home. The monthly fees are being subtracted, and then she's receiving, and then I think there's a $45 amount that she's allowed to keep in that account. When she passes, what happens to those funds?
Good question. So the money is, I'm presuming that it's going into a what they usually will call a resident account for her. And then any balance that's going to be in that account is going to technically be an asset of her estate when she dies. And when you told me about that $45 a month allowance, that tells me that she's on medical assistance, that Medicaid is paying for her care, in addition to her Social Security income going toward her monthly cost. So when she passes away, Medicaid is going to send you a questionnaire that is going to ask you to report any of her assets, bank accounts, if she owned a house, anything that she might have owned. And there's also going to be a question about a nursing home resident account. And most likely there's going to be a balance of at least something in the account that she has there at the nursing home. And you're going to have to report that on that questionnaire. And then depending on the balance, if it's above $2,400, then that money is going to be subject to estate recovery and would have to be paid over to the Department of Human Services as part of her Medicaid claim. If it's under $2,400, then you should be able to keep it.
Okay, thank you.
You're welcome.
I think she's nearing that $2,400 threshold now. So that money can continue building in there. I don't have to take it out or spend it, but that the amount over $2,400 will be forfeited, basically?
No, the whole amount. If that account totals $2,500, they're going to take all $2,500.
Okay.
Less any kind of administrative costs, or if you have to pay like for a funeral for her, they'll let you pay a funeral before Medicaid gets repaid.
Okay, and Medicaid will send me that letter as opposed to the nursing home?
They'll usually either send it directly to you, or they'll send it to the nursing home, and the nursing home will give it to you.
Okay, all right, thank you.
You're welcome. Any other
Lauren,
questions?
would you advise Elena that she should try to spend that down for her mother's benefit at this time?
She can, and most of the time that money is going to be there for things like miscellaneous things that she might need, like personal care items or haircuts. You know, those kind of miscellaneous expenses are usually what that money is going to be used for. You know, obviously, if she doesn't have any of those kind of expenses, then I'm not necessarily going to advocate for frivolous spending, but I do understand your question and agree that if there are things that she does need, you can certainly use the money that is in that resident account for those purposes. And if she doesn't have her funeral paid for already, which I'm guessing she probably does, because most of the time that's one of the first things that nursing homes tell you to do. But if not, or if you feel like she might need a little bit of extra money added to that, then you can use the money in that nursing home account. You should be able to take it out for that purpose too.
Thank you.
Mm-hmm.
We have another question from Beverly Morant. Beverly?
Hello. Hi, Lauren.
Hi, Beverly.
I have a question for you. I was just thinking about that payable upon death that you've mentioned. So my mother has 2 accounts, and I've been thinking about putting them as payable upon death. So I wanted to ask, if money is inherited, how do you pay the inheritance from those accounts, from the money that's...
Do you mean the inheritance tax?
Yeah, the inheritance tax.
You can pay it from that account, or you can really pay it from any source. I think that they figure that it's going to get paid out of that account, out of the proceeds from that account.
Okay.
But quite honestly, they don't care where the check comes from.
Okay. So do you need to register the will if the accounts are payable upon death?
If there are no probate assets, like for example, if it's just 2 bank accounts that are payable on death, then no, there is no reason to file the will.
Okay. So then how do you go about paying the inheritance tax?
Good question. So depending on the bank, most banks are going to report a person's passing once they are informed of it. They're going to report the excuse me, one second. Sorry about that. They're going to report the death to the Department of Revenue. And the Department of Revenue is going to send you a notice that's basically looks like a tax bill. And it says, you know, this is the account that it was, this is the person who passed away, this is the bank, this is the date of death balance, because that's what it goes by. And this is how much you owe in terms of the tax. For inheritance taxes, if you pay within 3 months of somebody's date of death, then you actually get like a 5% credit. So it's advisable to get it paid as soon as you can. But most of the time you're going to get those notices, and then you can just pay it off of that notice, and it gives you instructions. Sometimes, and I can't give you a reason why, but sometimes banks don't report it and you don't get those notices. And I always tell people that if it's been 2 months and you still don't have that notice, you might want to contact an attorney about filing an inheritance tax return, because you can still file the inheritance tax return without ever having to open an estate or filing a will.
Okay.
Okay. So there's kind of 2 ways that you can do it.
Okay. I didn't realize that. I thought you would have to file the will.
Yeah. Nope.
Okay. Great. Thank you.
You're welcome.
Okay.
We have a few great questions from Patsy, starting with how much money do you need to benefit from having an irrevocable trust?
I would say that there's not necessarily like a hard and fast number. To me, it's more about you have to have a comfort level with being able to take a certain amount of money, no matter, it could be $500,000 or it could be $50,000. It just depends on what your intentions are and what your goals are. But you have to have a comfort level with taking that amount of money and knowing that you're never going to be able to use it again. It's almost like you're spending it. And for some people, obviously, if you have less in your savings, there's going to be less of a comfort level with that. And you're not going to have as much peace of mind, because a lot of times people say, well, I'm still relatively young and healthy and I live in my own home. What happens if my roof needs to be replaced and I need that $20,000 or whatever the number is. For myself personally, I don't usually recommend irrevocable asset protection trusts unless somebody has, at a minimum, $250,000 in terms of assets. And again, that's not a hard and fast number, but I think you kind of get hopefully you get the idea, at least as to how I analyze it.
Laura, the next question asks, if a resident with dementia, are they able to legally appoint a POA? How do you determine that?
Sure. So the answer is maybe, and it really is going to depend on the individual's current cognitive ability at the time that they are signing the power of attorney. As we all know, a diagnosis of dementia does not automatically mean that that person is incompetent or incapable of making decisions for themselves. Oftentimes, once someone is in a nursing home, especially if they are in like a dementia ward or a memory care unit, at that point, then a lot of times they might be past that point of having the cognitive ability. But I'll normally sit down with someone and I'll ask them questions about their family. I'll ask them questions about where they are and who they are and what they did for a living, or, current events, and all of those basic questions is to try to ascertain what that person's level of understanding is. And if they seem like they're able to have that intelligent conversation with me, then I'll start to talk to them about the power of attorney document itself. And if they're able to understand what that is and who their agents are going to be, and generally what their agents are going to be able to do for them, if they can understand and relate to all of those concepts, then I feel comfortable with a person who has a diagnosis of dementia signing that document. If I don't have all those things, then normally I will not have them sign it.
So excuse me, this is Patsy. I'm the one that did the question. Can you hear me?
Yes, I can.
Okay, so I work at a nursing home, so we have like a notary, but we don't have a lawyer on staff or anything. Mm-hmm. So I have a gentleman, his family actually live out of state, and the wife isn't very healthy either. So she wants him to do a new power of attorney, making the daughter the alternates. Mm-hmm. I think that he would know his wife and his daughter. He would recognize them. And I think he would understand to a certain extent, but he can't tell me what day or time. But that, you know what I mean? Could I safely have sign? You know what I mean? I'm a licensed social worker. So I'm always just, all about the ethics and the, right thing. And
well, I'm going to say you probably could, but honestly though, my bigger concern is that depending on where that power of attorney document was pulled from, I have found that a lot of them are not the current form, and a lot of them don't necessarily have all the bells and whistles that will allow the agents to do what they need to do. So you might want to get an attorney involved just for that reason.
I don't know that he has the resources for, that's the other thing. A lot of our residents are not willing or able to pay for an attorney,
Yeah. If push comes to shove, I would say that the most important questions to ask are that they are familiar and they know the person that they're going to be appointing as their agent, that they understand what they have in terms of assets, at least, again, generally speaking, and that they have a basic understanding of what the power of attorney is going to let the agents do. And if the person can relate to and understand all of those things, then I would say that they would probably have the capacity.
Okay. He probably would not understand what finance, even he worked in finance his whole life, but he would probably not be able to comprehend what assets he had or what money he had. But, you know, I would probably explain to him, they are going to help take care of your bills and your care and, you know, something more like that. Okay.
Yeah, that's a tough one.
Yeah, I always have the tough ones. Thank you. A very enjoyable topic, though, in session.
And Patsy's final question asks about removal of a guardian. How difficult is that? What's that process?
It's going to involve filing a petition with the Orphans Court requesting that the current guardian be removed for whatever reason and that a new successor guardian be appointed. I would say that the process itself is not difficult. The procedure isn't difficult. It obviously would depend on if it's a contested matter, then there might be a little bit more involved with it. But the procedure itself is pretty simple. It's just a matter of filing that petition. Depending on the county and the court that you're in, the judge may or may not want to have a hearing on it. But normally then they're going to, if it's not contested, they'll go ahead and grant it and they'll issue a new order with a new guardian.
Okay, this is me again. It's definitely going to be contested, but I guess the base of the issue is the gentleman, he's incapacitated. That's why he has a guardian, but he's the one requesting it's his spouse and they're kind of estranged. And can we do it on that grounds that he wants it, even though I feel like he doesn't have the ability, but I feel like he's incapacitated. How does he have the ability to make that request? I mean, anyone can ask anything, but.
Well, so the current guardianship laws provide that an incapacitated person can still file petitions to have the guardianship revoked or terminated or removed or, you know, any of those things. So it honestly is the ultimate determination will be up to the judge.
Right. And he might not appoint the person or the judge might not.
Might not. Yeah.
Right.
And the judge might not do that.
Yeah, and I tried to explain that to him, like you might get something worse, you might get a perfect stranger, you know. So, all right, well, thank you for being all my questions.
And Donna has a scenario to run by you. 2 cousins were adopted by another family person in PA. When one of the cousin dies and the other inherits her estate, does the beneficiary pay the inheritance tax rate of a sibling?
That's a really interesting question. And I will say yes, that they would, when they were adopted by the same parents or parent, their adoptive parent is their legal mom or dad, and that would make them legally siblings, even though by blood they would be cousins. I'm going to say yes, they would pay the 12%. That's the sibling tax rate.
I think that's all that's in the chat at this point, unless anyone else has something to add.
I have no questions in hands at this point.
Great.
All right, Lauren, thank you so much. This was such a wealth of information. Thank you.
You're so welcome. And please, everyone, I think that my contact information was back on that first slide.
It is. Yep.
So if you ever have a question about something, please, feel free to shoot me an email or reach out to me. And if I can help in any way, even again, if it's just a simple question, I'm happy to answer it if I can. Thank you for having me.
Thank you. Thank you so much. Before everyone else jumps off, we want to just cover a couple things. We want to talk about our upcoming meeting, as well as some breaking news. So our next scheduled meeting is going to be on August 24th. We'll meet at the same time at 4:30. We will be covering resident rights in assisted living facilities and personal care homes, and that's going to be presented by PA Ombudsman. So that is what we have tabled for our next meeting. And then we do have a special announcement. Okay, so the Pennsylvania Department of Health is looking for public comment on the first of 5 skilled nursing facility regulation packages. In the first package that was released last week, they proposed an increase of the number of care hours that our residents receive by 1.4 hours each day. These regulations have not been updated in 22 years. Because each packet is only published for 30 days of a public comment period, it is essential that we move quickly. That's why the Ombudsman Office is encouraging all interested stakeholders, resident advocates, and the general public to join us for a very special meeting next Tuesday at 5 p.m. to learn about these proposed changes and to learn how to reach out and make our voices heard. 4.1, it absolutely can be done. So please join us next Tuesday. Tell a friend, tell your neighbors, tell everyone. We want to make our voices heard. And with that, that does it for our meeting.
Liza, Donna just commented here. She wants to know where they submit comments on the nursing home changes. I assume if they can't make next Tuesday's meeting.
That's all going to be covered next week at the special meeting.
And it will be recorded so she can go back to the website, to the Facebook site and look it up. Eliza?
Next week, yes, that meeting should be recorded as well.
Yes.
Yep.
Will we get an invite sent out like we do for these?
I believe so. Yep. I believe it's going to go out through the same link that this is.
Excellent. Thank you.
All right, guys. Thank you very much. Thank you for putting up with me tonight. And we'll see everyone next week at the special meeting.